Welcome, everybody. I'm Diane Drain, Co-Executive Director of Arizona Consumer Bankruptcy Council, and also on the CLE committee, along with Lisa Thompson, who's here today. So Lisa's going to introduce the program and the speakers and all. Whoops, that's reminding me to go start the recording. Okay. A little housekeeping though. If you've signed on, say with a phone, make sure that your name is on there. That's the only way we can keep track of CLE in case the state bar comes back and asks us to verify that in fact you were here. You will get your CLE certificate at the end of this. And then also, as far as keeping your microphones muted, please. Certainly when we get to the end for questions and answers, you're welcome to turn your microphone on. Our speakers, Kenn, Neeley, and Sarah Berry, have decided to take questions through the program, but they're the ones that are in charge. If they decide to put it off, then that's certainly up to them. The materials, I have just posted them to the website. So they are over at in public area where, because we have many people here that are not members of ACBC, where they can retrieve the materials. And I just posted them to the chat. I will post them again in another couple of minutes, but I don't know about you, it's kind of hard to download this stuff from the chat to wherever it is you want. So maybe going to the website is a more efficient way. And then your CLE certificate will be at the end of the program. Traditionally, even once we get through with the program, if there are still questions and all, our faculty stays to answer what they can. And so that's all I have to say, unless Lisa, you want to take it over? Is there anything I missed?
Well, I just want to thank Kenn and Sarah for presenting to us today on this very important topic. I have worked with the Neeley Law Firm and have sent my clients there. So I definitely think if it's not an area of practice that you have in your quiver of arrows, that you definitely think about sending your student loan cases elsewhere. And I greatly thank you and Kenn and Sarah for being here. So without further ado, I'm gonna let you guys take it away.
One point before Kenn takes over. This is being recorded. You are able to access this recording at any time. We will have it both on our website and our YouTube channel. So go ahead, Kenn.
Thanks, Diane and Lisa. Excited to present on this today and excited to have one of my new associates, Sarah, joining me. She's already become quite proficient in working on these cases, and you'll hear from her as she'll be talking about some of the real nuts and bolts of handling these cases in a few minutes. But I wanted to start with just, so in the materials, you'll see a short bio on me. I'm not gonna really spend too much time introducing myself. I know I'm looking through the names of everyone here, and I think I know almost all of you. I don't see very many names I don't recognize. But do take a minute to look at Sarah's bio, and for those of you who do consumer work and in bankruptcy, which is most of you, hopefully you'll be kind of seeing her around the courthouse as we're getting back to some in-person hearings and at various, ACBC meetings or in-of-court meetings and other things like that. So, all right, I wanted to start with a few things. One, some rough numbers, and then tell you kind of what we've seen here at Neeley Law, and then talk to you about one relatively new development that's exciting. As I introduce and kind of kick this off, and then I'm going to wrap up at the end after Sarah's portion is complete. I'm going to attempt to maybe even go as far as try to convince some of you who do consumer bankruptcy work, Chapter 7s and Chapter 13s, to consider bringing some of these cases. Okay, so my point in taking the time to present today, my goal is not to have people refer to me. I will certainly appreciate and take good care of any referrals, but I think would be just as excited to hear from any of you that you're going to be, trying some of these cases, and I would be happy, and so would Sarah, happy to help and share thoughts, advice, forms, whatever we've learned with you. So I want to preface the whole presentation with that. I know there's some of you don't do consumer work, and there will be hopefully value here for you as well to kind of hear the firsthand experience that we are getting in dealing with the Department of Justice and to some degree the Department of Education. Most of our interaction is with the Department of Justice, and just kind of hear and see what's happening in these cases. We have, I wanted to count before how many of these we have filed already that are against the Department of Education. I know it's over 30, maybe 40 that are active right now, cases, and about another 40 that are getting prepared to be filed. Not all of those in Arizona. So if you go on Pacer and search in Arizona, it's probably about half of our cases in Arizona, but we're doing these across the country. So our experience and what we're seeing is not just isolated to what we are seeing in Arizona. We're dealing with assistant U.S. attorneys in a handful of other states, probably 6 or 7 other states right now. So, all right. So some rough numbers. Unfortunately, I wasn't able to get updated numbers. I've been trying to find them. I don't even know who releases them, but I do have numbers from about 4 months ago on the number of these cases that have been filed, how many have submitted attestations, and then how many have been recommended for discharge. So let me pull those numbers up. So as of a few months ago, there were 409 complaints against the Department of Education on federal loans, and 205 had submitted attestations of those. So about half had made it to the attestation process. If I had to guess where we're at now, I would guess that in the last 4 months, probably about that same number has been filed, even though that prior number was covering about 8 or 9 months of the new guidance. It is accelerating in our participation in national student loan listservs and in our communications with attorneys in other states, and even here in Arizona. We're seeing more and more people, more and more attorneys filing these, more and more debtors that are seeking this relief. So if I had to guess, there's probably close to 1,000 new complaints, and that will be more in 2023 than I think in any prior year ever since student loans were made non-dischargeable in bankruptcy. So in prior years, a total number of complaints that were filed against the Department of Education on federal loans, was never just more than a few hundred, 200-300 total, and I think it was probably close to 1,000 last year. So, and it will be even more this year, I would expect. Of the 205 new attestations, a lot of them were still just pending, okay? But 70 had been recommended for discharge, 70 of the 200, and 32 had been recommended not for discharge. 24 were recommended for partial discharge. So some quick math, that's 125 of the 200 that had received some kind of recommendation. But if you do the math on the partial discharges plus the discharges, which ones were recommended, that's 94 out of 100, and what is that, 126, something like that. So it's around that 80% mark, which we heard from the Department of Education was the goal. The goal was to hope and goal, I guess, when this new guidance was released in November of 2022, was that about 80% of people who participated would end up receiving a full or partial discharge. So that seems to be playing out, and that's exciting. I'll tell you here internally at our firm that it's at least 80% that of the ones we know what the result is going to be. Some we have not received back from the Department of Education, but the Department of Justice, the AUSA, has told us that it has gone in with a recommendation of full discharge. Now we're just waiting for it to go through the committee at the Department of Education and to come back to the AUSA to draft up the documents to settle the debt and dismiss the case. So we're seeing at least 80%. I think it would be even more. I can only think of one case off the top of my head where it didn't go into the case didn't go into the attestation process at all. It was admittedly a case we took that's a little more borderline, and that the client, was educated on expectations that, this is maybe a little bit more of a long shot. And the Department of Justice on that case just told us they're going to answer the case and they're going to put it in a more standard litigation track. I do believe that case will end in a partial discharge. But it's just a higher income. It's not one that is really well suited for these new guidelines. So, but other than that one, I think across all of our other cases, Sarah may know of another one or two that are meeting some resistance. But for the most part, if you are good at screening the cases and finding the ones that will meet those requirements in the attestation that Sarah's going to talk about in a few minutes, then the success rate is very high, if not, approaching 100% if you're good at picking the right cases. So that's what we're seeing. We're also seeing a lot of demand, which is probably not a surprise, because all those of you who meet with debtors, you hear about student loan concerns all day from your clients. And so those concerns come to a head with, those debtors reaching out to us and then asking if there's, some way we can help them. And the demand is high. So we're before the meeting started, we were just chatting with Lisa and just talking about how she asked, well, is it ramping up? And I would say the demand is ramping up. I would say, we're having a hard time ramping up the resources here we would need to keep up with it. So we have to kind of throttle even the amount of intakes that we do in order to be able to competently and effectively take care of our clients. But we are getting more and more efficient and effective and ramping up those resources to the degree that we hopefully will be able to help more people. That's really our goal, is just to be able to help as many people as we can. If we can't help them, then a lot of times they can't find other options, right? So that goes back to how I started this CLE off with just mentioning that I would love to see some of you trying some of these cases, because I would love our clients to have options out there. And if they go do a Google search for someone that can help me discharge my student loans in bankruptcy, they'll find a few different attorneys here in Arizona that could help them. All right, and some exciting news, the new FEL guidance. So what happened just a few months ago is the Department of Education issued some new guidance. It's in your materials. And I suppose we've heard that those are called a Dear Colleague letter. I'm not exactly sure what that means. I'll just be totally honest with you. I don't know exactly what a Dear Colleague letter is, but apparently the Department of Education can issue guidance out to FEL lenders who are guaranteed by the Department of Education. And that's what they did a few months ago. And in that guidance stated that the FEL lender can meet the requirements of the regulations to kind of protect that interest and qualify to receive the federal guarantee, qualify to be paid out by the Treasury on the federal guarantee, by following the same guidance that the Department of Education released for its loans that it owns. Okay. So that felt like I explained that a little awkwardly, but let me try it maybe one more time just to make sure it sinks in. So in November of 2022, Department of Education and the Department of Justice released guidance that said for loans owned by the Department of Education, direct loans, loans that went into default and came back to the Department of Education, consolidated loans, all those loans are owned by the Department of Education. They released the new guidance, which streamlined the discharge process. Hopefully that part's not new to most of you on the call or on the Zoom. And we're not getting into really detail on all of that guidance, apart from Sarah's going to go through some of the nuts and bolts of kind of the attestation process, which is part of that. But what happened recently is that same guidance was extended to FEL lenders, where before the FEL lenders would just litigate it, right? So it's really common to have these guarantee agencies just litigate. ECMC is the big one that just litigate the student loan and not go through a more streamlined process. So it is voluntary by the FEL lender and or guarantor. So we have 2 cases with ECMC, and in one they are going to follow the guidance, the new guidance, newish guidance, and we are going to go through the attestation process, and in the other one they're not. So I don't know how they decide for sure, but it was made pretty clear to us that it's an optional decision by the FEL lender in, I imagine, in consultation with counsel that they hire. So but it is encouraging, even though it is optional, it is encouraging. I think it lends itself to student loan discharge work in general as a whole, becoming a more realistic way to deal with student loans. And so we're finding that, to give you some numbers on the total amount of student loans, so 92% of all student loans are either federally guaranteed or owned by the Department of Education. So most, right, almost all, 92%. And then of those, 7% are FEL loans that before the guidance didn't apply. Now it does. So now 92, or now it could, I guess, in some cases will, if the FEL lender opts to follow the guidance. So that means now 92% of student loans have a chance, at least, for this guidance to apply. 85%, which is the amount owned by the Department of Education, the guidance will apply. And then the other 7% that's owned by commercial lenders, FEL lenders, it may apply. So that was exciting, something we hope to see, and it has happened, and it just opens up more opportunities, more options for people. So quick overview of the process, and then I'll hand it off to Sarah. So I'm going to spend a few minutes talking about getting these cases and making money off these cases, kind of some marketing, some high-level marketing tips and ideas, and some fee structures. But I'm going to leave that to the end. So it's my little teaser, my little hook, to keep you here paying attention to the end. What I am going to talk about right now for a minute is just filing this adversary proceeding. So getting this process started, getting it to the attestation, which Sarah's going to talk about. How do you get to that point? Well, it starts with filing an adversary proceeding. Okay. Same as how we used to have to seek to discharge student loans before this new guidance. We just would file seeking a declaratory action, seeking a declaratory order that the student loans were discharged in one way or another, right? Generally undue hardship, but there are other ways that are outside the scope of this presentation also to deal with student loans. But in the scope of this presentation, to prove undue hardship, so you file that adversary proceeding. What if the bankruptcy case is closed? Well, it will require in most circuits, in most districts, to reopen the bankruptcy case. It's prudent to do, certainly in the Ninth Circuit. That's, if not the law, it's certainly the custom to reopen the bankruptcy and then file the adversary proceeding. So that's not really too exciting or interesting to most of you that have ever filed an adversary proceeding. You probably know that. The reason that it's worth talking about right now is because in the guidance that was released, the original guidance that was released in November of 2022, there is a mention of the guidance only applying to proceedings that are open, that are either pending on the date of the guidance or after the date of the guidance. And it uses the word proceedings. Okay, so I use that word very intentionally. It says this guidance applies to proceedings that are opened after this date or that are pending as of this date. Okay. What I have been told from people that were in the committee and or consulting and advising the committee that drafted those guidelines, what I've heard is that the intent was to say this applies to bankruptcies that are pending as of today or that are filed after today. But that's not what they wrote. They wrote proceedings. And to me, proceedings is a term of art in bankruptcy, meaning an adversary proceeding. And the adversary proceeding, and I think it also makes a lot more sense to have the new guidance only apply to proceedings that were pending and or filed after. And let me explain why. Who cares if it applies to an old bankruptcy? You still have to bring a new adversary proceeding and prove all the facts now, right? So I can see why the Department of Education wouldn't want you to go reopen an old adversary proceeding and say, I lost that one. You guys beat me. And or it got dismissed because for whatever reason, right? And now that this new guidance is out, I want to reopen an old adversary proceeding and I want to relitigate it. That's a problem, right? That for various reasons that we don't need to get into, but that would cause a lot of confusion and complexity across proceedings that have been filed over the last, say, 5 or 10 or 15 years. But if it's an old bankruptcy, I don't see that it's really a harm, a problem, a burden on the Department of Justice or Education to allow you to reopen an old bankruptcy and file a new adversary proceeding and apply the guidance. Okay, so we have been told from different AUSAs different things. So we've heard the guidance absolutely applies to a reopened bankruptcy, even a bankruptcy that's older than the guidance. And then we've heard it absolutely does not. And then we've heard we don't know. So we are reopening cases in several different districts and circuits, and we'll know a lot more in the next few months if the Department of Justice ends up saying we're not going to apply the guidance in this case. I'll try to share that with as many of you as I can. I'll certainly share it within ACBC and in other places that I have channels to share it. So, but at least for now, I believe that there's a really good argument that even reopening a case from before the guidance should be fine. And I would not be hesitant to try it. And we are trying it. So putting my money where my mouth is on that belief. So certainly if it's an open bankruptcy that was open during the guidance, even if it's closed now, but it was open when the guidance was issued on November 20th, Sarah, 2022, something like that, then you're absolutely okay, even to reopen it because it was pending on that date. So once you file that adversary proceeding, instead of an answer being filed by the Department of Justice, what is happening is we're getting an email, usually from an AUSA, saying, would you like to participate in the attestation program in this case? And of course we say yes. And then that AUSA drafts up a stipulation to extend a stipulated motion to extend all the deadlines in the case and runs it by us. And we look at it, and generally we agree. The deadlines usually get pushed out by about 90 days. Sometimes the reason I put stipulations in the slide is because sometimes, in fact, in every case so far, 90 days has not been enough. So there's been another stipulation to extend. And in some, even 3 stipulations to extend, and we'll probably hit 4 stipulations to extend in some of these. We're even trying to push it out a little more than 90 days, but the judges, understandably, they want to keep their finger on the pulse of the case and not have deadlines and everything extended too far out. So we're commonly doing a 90-day extension with a hearing set near at the end of that. And then when we do a new stipulation, we're asking to continue the hearing out again 90 days. And most of the judges are totally fine with that and are doing that. A few will still want to hold the hearing, and they'll just ask how things are going, which I like, actually, because we'll hear some information from the assistant U.S. attorney commonly in that hearing that we won't hear from them if we're just emailing and asking for a status. So we might email and ask for a status, and they might say, working on it. And then we get to that hearing and they tell the judge, this is a real example. They tell the judge, I recommended it for discharge. Awesome. Like, I mean, this is news to me too, right? And, but it's good news. It's great news. So I don't mind, especially right now, as those hearings are quick and easy by Zoom. I don't mind that. It could get a little more burdensome if we're having to drive into court for those hearings. But for now, it's working to kind of allow us to get an update via a court hearing from the assistant U.S. attorney. And then now Sarah's going to talk about the attestation and possibly touch on kind of wrapping the case up. If not, I'll talk on wrapping the case up and a few more things at the end, including questions and answers at the end. So, all right, Sarah, take it away.
Awesome, thanks. All right, so the attestation covers a lot of information. Your personal information, pretty self-explanatory. Then we cover the inability to maintain minimal standard of living. So this is the first prong of showing undue hardship, and they have just compiled it into a form. We'll get more into that later. The future inability to repay and prior efforts to repay the loan. We won't get too much into assets. We'll touch briefly on additional circumstances. So the personal information you're going to, again, is pretty standard: household size, residence information, employment information, loan and educational history. Now, the AUSAs are supposed to provide a packet, a litigation packet, and in that litigation packet, they should have this information. So it will show a complete history of the loan, all of the schools that were attended, whether they graduated, withdrew, all that fun stuff. It can be kind of difficult to get this from the AUSAs, but it's really important because question number 6 on the attestation is really hard for clients to find the information to answer it. So if we can get the loan and educational history and just agree that it's accurate, we don't have to answer those questions. We can skip right over them. So it's really important to advocate and work with the AUSA to get it. Some of them are sending over 150-page documents, so it's a lot to comb through, and others kind of pare it down into a 10-page document. Right, and so when we're looking at the inability to maintain minimal standard of living, again, that's that first prong of undue hardship. The attestation is going to ask you for income information. Generally, the AUSAs are requesting to see like 4 pay stubs from each employer for every member of the household or the recent tax returns. With the monthly expenses, you've got the IRS standards for living expenses. Those are going to be food, clothing, laundry services, personal, non-medical personal services, but you actually get the actual expenses for vehicle and housing related items. So whatever their rent is, you get to claim that. It's not subject to the IRS standards. So think of this as a balance sheet. You've got the gross income and the monthly expenses. You're going to deduct all of that, and at the end of the day, you're going to be able to have a good idea whether or not this is going to be someone who's a good candidate for a discharge, whether that's full or partial. And so when you're looking at the attestation, you're going to have opportunities to advocate for your client. So when you're looking at the IRS standards, if you're looking at the groceries and they exceed it, this is an opportunity for you to explain it. Do they have a toddler and an infant and they're buying formula and also, you know, baby food? Are there dietary restrictions? Like, this is your opportunity to explain who your client is and advocate for them and say, yes, these are the IRS standards, but they shouldn't apply here, and this is why, and try to get them those additional deductions. Same thing with the uninsured out-of-pocket medical costs. You know, if they have medications that are really expensive that are not fully covered by insurance, they're paying for every month. This is your chance to explain that to the AUSA. Same thing in actual expenses. So there might not be a category where you see, hey, they have this expense, but it's not anywhere on the attestation. You can add it. Dependent care. You know, why are you taking care of this person? Why does this person need this level of care, and why are you having to expend this amount? Take the time to explain the circumstances when they give you the opportunity to, because once this attestation gets shipped off to the Department of Education, there's no way for them to see this person. There's no way for you to personalize them any further. So you have to use this attestation to really paint a picture of who this person is and humanize them. Again, same thing with babysitting and daycare. You know, if kids are going to need braces in the future, or if someone's got a degenerative disease and care is going to start increasing, that's a great place to advocate for them and explain why their income might look, you know, sustainable right now, but it's not going to be in the future. Okay, and future inability to repay. This is like a checklist. You're going to go through, if they're over 65, if the loans have been in repayment for 10 or more years, they didn't complete the education, they've got a disability or chronic injury, unemployment can have an impact too. If they're over 65, there's a presumption that they're going to have a future inability to repay. And this applies to the majority of the repayment period. So if they've got a 20-year repayment period and they're over 65, like, yeah, this future inability to pay is definitely going to extend into the future. Again, you can advocate in other ways too, the other circumstances, whether the institution closed, whether they can even get employment in the field that they've been educated for. Those are all things that are important. And you should check every one of them that you possibly can. Prior efforts to repay, this can be another tricky one. So you're going to need the payment information that they ask for, the number and amount of regular payments. I mean, this could have fluctuated. They could have been on an IBR and maybe not on an IBR, or their income had changed, so the IBR payment changed. Worst case scenario, you say they made at least X number of payments at a set amount. I haven't seen that be a problem with anyone yet. I don't know if Kenn has either, but I mean, this information is really difficult to pin down. As far as forbearances and deferment. So if you can get their NSLDS, which you absolutely should, that should be the first thing that you get from them. You can go to, I'm not sure how much he appreciates us using his website, but it seemed like he was open to attorneys using it. It's Tate Stanley. He's got a free reader for this NSLDS, and it will break it down really, really well and show you when were they.
Explain what that NSLDS is real quick.
Oh, so the NSLDS is just a compilation of their federal loans, when they originated, how much the original amount was, who the current servicer is, all of the fun stuff. And it comes in a text file, and it's just pages and pages of dense information. So using a student aid text reader like Tate has is going to be super helpful. It's really hard to make heads and tails of the information without some kind of filter over it, paring down the information. And like I said, the student aid text reader that he's got actually will break down the repayment periods, how many deferments, what deferments. It's really nice. It's a really user-friendly thing, and it's totally free. You just have to put in your email.
Yeah, this is a great place to start, because most student loan borrowers, maybe most isn't fair, but a lot of student loan borrowers don't know if their loans are federal loans or private loans. They don't know, among the federal loans, are they federally owned or just federally guaranteed. And so anyone with a federal loan, whether it's just a federally guaranteed loan or it's owned by the Department of Education, can access this file by going to studentaid.gov and then downloading the text file and sharing that with you. And that will give you a really good overview of what the federal loans are. And if the loans aren't on that, that means they are private loans. So if they say, yeah, I know I owe 80,000, I went to this particular school, I don't know who I'm paying, but it's not in this data file, then it's a private loan. And probably would show on a credit report, or, you know, the client could hopefully track down some kind of a statement or something that would give you more information on who that private lender is. So, all right. Go ahead, Sarah.
And the prior efforts to repay, that's just letting them know, like, you can, every time they've called the servicer, every time they've reached out or applied for an IBR, like, those are all things that are going to be taken into account to show good faith efforts to repay. It doesn't have to be that they made payments. They could have never made a payment on it, or they were on a $0 IBR the whole time. That's not going to negate a finding of good faith efforts.
This prong is not one where I think we've ever had pushback. It's more about current ability and future ability. And so at least that's where we've seen the focus so far. This one hasn't been a challenge to date.
Okay, and the last section that you come across is going to be additional circumstances. So this is, again, another opportunity to advocate for your client. Anything that you weren't able to shoehorn into any of those other opportunities, this is where you want to explain it. Are they a single parent? Do they have a child that has medical conditions? Do they have medical conditions? Tell their story. What has happened to them since they graduated that has made it hard for them to utilize that degree to the best of its ability, or that made that degree not pan out the way that it was supposed to? Here, you're going to see that the AUSA is going to ask for, so both in this prong and in the future inability to pay, you're going to see them asking for documentation. It's going to feel really invasive. Medical records, letters from doctors explaining what's the diagnosis, what's the prognosis, how does this impact their day-to-day. If you can get those things, you're going to make a really good case. And again, this is all going to go to a person who has no idea. These are just numbers to them, right? So you really need to bring your client to life and make them realize this is a human being and life has happened to them, and you know, this is why they meet the standard for undue hardship. And just kind of like what Ken said, this is a very drawn out process, and the stipulates to stay are going to happen all over the place.
Sarah, talk a little bit about the requests for documentation, because if you go read the memo, or if you have read the memo from November of 2022, there are a few mentions in the memo of the purposes of the new guidance, and one of those purposes is to reduce the amount of actual documentary evidence that needs to be produced or requested from, say, I think it even specifically mentions medical records. It's to prevent a burden on debtors having to go track down medical records. Talk a little bit about kind of what we've seen and what your thoughts are on that.
So the guidance does say that it's to reduce the burden on what are they, lofty discovery or something, worded something like that. However, it does say that the AUSAs are able to request more information if they need it. So if you submit it and you give them, a letter from a doctor and the 4 pay stubs, they can come back and say, this isn't enough, we need some more. And there have been instances where that has happened. And a lot of times though, the AUSA is trying to work with us, is what I've seen, is they're saying, hey, we need more, because if I don't do more, the DOE is not going to entertain this. So it doesn't seem like they're doing it in bad faith. It seems like they're trying to help the process and make sure that, discharges are happening for people who need them. Again, we start out by sending them as little as possible and seeing what they kind of push back with and say, hey, we want more of this, we want more of that. And then we respond to it appropriately there.
Thank you. Yeah, it's probably one of the primary challenges in doing this type of work is just the inconsistency across the cases in the amount of documentation and proof and evidence that you will need to provide. And that's just because every AUSA is different, and they do have a fair amount of discretion in what they want to see. So even within the same district, even here in Arizona, it can be quite a different experience with different AUSAs. Now, I will say that I've been thoroughly impressed with the professionalism and the care that the AUSAs across the country that we've worked with have been putting into these. I think as we started to ramp up filing these cases, I was concerned that these cases might be looked at as kind of nuisance cases to an assistant U.S. attorney in the civil division that maybe wants to do something a little more interesting, a little more high stakes, a little more exciting. But I haven't seen that or sensed that at all. I felt like the cases are getting a lot of attention, maybe even sometimes more attention than I would like, right? Maybe even I am curious why they're spending so much time on these cases when they could maybe streamline it and push it through a little faster. So I've been very impressed, and it's been a pleasure working with the assistant U.S. attorneys across the country that we've had an opportunity to work with. So, all right, let me move ahead here. Does anyone have any questions on the attestation process before I jump into kind of some of these concluding topics and question and answer and kind of an open question and answer period before we move away from Sarah? Okay. Post them to the chat if you do. I don't see anything yet. So, all right. So let's talk a little bit about getting these cases. If you're interested in getting these cases, the best place is the obvious place, your current and past clients, right? People, if you do consumer work, your consumer clients ask you about options with student loans, probably starting right from the initial consultation. So now if you're interested in taking these cases, you can start screening at that point for a few different things. And I'll tell you that we're settling into wanting to see a balance of probably about 25,000 or more on the federal student loans or federally guaranteed student loans. It's preferable that balance is all with the best case, the best candidate. Those are all owned by the Department of Education, okay? Because that means we're just going to be dealing with one defendant, the Department of Education, and one attorney, an AUSA, and it just makes it much simpler. If some of the loans are FFEL guaranteed loans and they're not owned by the Department of Education, now you're going to have another defendant, you're going to have another attorney to work with. A lot of the work can be multi-purposed across those two defendants. You might produce, gathering documents and writing up some of these things, which I loved how Sarah spent some time talking about humanizing your client and really advocating and telling their story, because it is important and powerful in these cases to do that. I can't tell you how many times the assistant U.S. attorney will say, like, will express some empathy for the client situation, because in many of these cases there is some medical hardship. There is something that, in addition just to the financial inability to pay, the better hardship cases have also maybe some additional circumstances that are sometimes pretty tragic or difficult circumstances. And if you tell that story, you have a human on the other side, right? These AUSAs are going to empathize and kind of understand. And I think we've seen them, try to help us help them, right? To use a Jerry Maguire quote, and say, well, if you can, in fact, I know they have, because I've specifically had an AUSA say, if you can just show me this, this, and this, that will allow me to go make a recommendation for a discharge. So they're willing to help if they feel like the client is deserving, at least in the cases we've seen so far. So talk to those past and current clients about options. I've seen some attorneys go to their database and send out an email and say some changes have happened with student loans. Maybe when we talked in 2018, I told you there was nothing I could do about your student loans, but now there might be. If you would like to talk to me, we can look at your options to discharge fully or partially discharge your student loans. So I think that's a great place. I think just the demand is so high that just word of mouth is a powerful way to bring in these cases. If other bankruptcy attorneys that you work closely with know you're doing these types of cases, then they'll send them to you. Some other campaigns that work for bankruptcy, interestingly, it's the same ones that work, or I'm sorry, for student loans, it's the same ones that work to bring in bankruptcy clients. So if you have certain lead sources that are pretty good at bringing in some bankruptcy clients for you, starting to mention student loans on your website, in your Google ads, in blog posts, in newsletters, wherever it is that you're putting yourself out there to bring in bankruptcy clients, mentioning student loans, it's the same people, the same potential clients. It works in some ways more effectively because the demand is pent up. So you'll have people that see that information and then go talk to friends and family and say, hey, did you know that my bankruptcy attorney is now working on student loans and can maybe help you? And the cool thing about this, one of the surprises for me, has been that we end up getting a lot of leads who still need the bankruptcy. Okay, so they're coming and they're maybe choosing to hire us as their bankruptcy attorney because we do the student loan work, and they still need the bankruptcy in order to qualify to discharge the student loans. So it's rare, although not unheard of, it's rare that we do a bankruptcy just for the student loans, but we have done some of those now that we're confident in our ability to get some results. We've had at least 2 or 3 cases that I can think of where there was really no other debt apart from the student loans. And we achieved a great result by doing a bankruptcy and then an adversary proceeding and dealing with the student loans through bankruptcy because there weren't good non-bankruptcy options for those clients. So it opens up, it makes the bankruptcy pie a little bit bigger for maybe some of those people that wouldn't have filed bankruptcy 2, 3, 4 years ago. It also might make you a more attractive bankruptcy option if you can transition right into helping with the student loans afterwards. So that's been a surprise and something kind of cool that we've seen from advertising this. And then the way we do fee structures is we offer an option, right? And we offer that they can pay everything up front. But of course, most consumer bankruptcy debtors that are recently out of a Chapter 7 case, which is the most common scenario, they may not have $5,000 or $6,000 to pay to do this process. So we offer payment plans. Our fees kind of range if they're going to pay up front, kind of in that $5,000 or $6,000 range. If they're going to do payments plans, it might be a little bit more. But we found that that's kind of about the amount of work it's going to take. It is more work than just doing a Chapter 7 case. It's going to be more hours, more investment, and I think that it deserves probably a slightly higher fee just because it's a little more specialized and requires a little bit more expertise than that is not seen across the whole bankruptcy market. So not that it's hard to do, and not that anyone out there can't do it, but it's just right now not a common expertise that's out there. So I think that's probably good for this slide. Question about, besides Chapter 7 cases, the more common scenario, at least in our office, is we're doing them after a Chapter 7 discharge. It is entirely possible to do it inside of a Chapter 13 case. The special challenges, the special considerations that I think you would need to have would be exactly how you're going to get paid. So we've done a few here in Arizona. I believe actually that they've been all with Trustee Maney, and there's been a little bit of pushback on, we think you should probably bill hourly on this, not flat fee. I wanted to, our model is flat fee. We've been able to work it out because our Chapter 13 trustees see the student loan problem that these debtors, they're exiting bankruptcy, at least they were before some of the recent changes to student loan law, but they were exiting bankruptcy with like student loans that were enormously higher even than when they started bankruptcy. It just was a big problem, and our trustees our Chapter 13 trustees recognize that, and I believe that there would be a way to get paid fairly, to get compensated fairly inside of a Chapter 13. If you're going to do a case inside of Chapter 13, you of course can wait and do it towards the end of the Chapter 13 as well. Even after the Chapter 13, if you don't want to have to do it through kind of fee applications or whatever method might be required inside of the Chapter 13 case. Upsides and downsides to that, really the main consideration, I guess I would say the main consideration is, might the law change? I'm going to talk about this on the next slide. Might the law change? Might circumstances change for that debtor? Things like that you would want to carefully evaluate in deciding the timing. But it's certainly a valid option just to wait till the end. It could be the better option, in fact, but it is a valid option. All right, so thanks for that question. On to the final slide, at least the final substantive slide. So telling the future. No one knows where things are going. I was telling anyone who had listened to me near the end of 2019 that I felt like we had seen the bottom of bankruptcies, and we all saw how well that prediction turned out, right? So as we've had 4 years since then of declining bankruptcies, it does look like the bankruptcy demand is increasing. Bankruptcy filings in Arizona were up over 25% in December. We're getting a few more calls. We're sensing a little bit more urgency from the people we're talking to. So it does look like bankruptcy demand will be going up, which also means demand for help with student loans, because that just means more debtors, and that means more people with student loans and more potential candidates for undue hardship discharge. In your materials is a really great article. It's long, but it's from 2020, but it's still very relevant today, by Professor Iuliano, talking about the bankruptcy discharge, the student loan discharge gap. Why are there so few people getting discharged when there are so many candidates? And in there, he mentions the number of people. He did a statistical analysis where he pulled a sample and he evaluated the cases, and he said these ones should meet the qualifications for undue hardship. What percentage then of the overall whole should meet the criteria for undue hardship? It was an enormous number. It's in that article, but my recollection is it was around 25% of the total bankruptcy filers have a student loan and would probably qualify for either partial or full discharge. That is a huge number, huge number. That would mean just here in Arizona, there's 2,500 people, 2,500 bankruptcy cases. It's even more people because some are joint cases, right? But that would mean there are 2,500 households in Arizona that filed bankruptcy last year that could probably benefit from a student loan adversary proceeding. And the number that was actually filed in Arizona, I don't even have it, but I'm sure it was probably under 100, if not under 50. So the demand is enormous and will only be going up as bankruptcy filings go up. So again, I urge you to consider trying some of these cases and seeing how it might complement your practice area. Politics and student loans, the one question I get asked is, what if the administration changes around a year from today? Gosh, we're coming up on almost exactly a year from today that the administration could change. Will we lose this guidance? Maybe. The arguments that it won't change, even if, say, we have President Trump back in the White House in a year from today, is that this program, this guidance started under President Trump and Secretary DeVos at the Department of Education. It was finished with Secretary Cardona under the Biden administration. And I don't know if it would have looked the same. It probably wouldn't have looked the same under Secretary DeVos, but it was the initiative was at least started. So that's an argument that President Trump, if he comes in January of 2025, could just keep it. But also, the argument on the other side is that in politics, student loans have become a lot more of a hot button issue. It's a lot more of a polarizing issue, I think, than it was 3 or 4 years ago. For better or for worse, probably mostly for worse, that it elicits more emotion than it should. If it's a problem that is not going away under the current approach, right? None of these are all band-aids, and they're not even good band-aids. It's great to finally see some things changing around student loan relief and options for borrowers, and a little bit easier process to discharge in bankruptcy, and all the things that we're seeing. There was some new guidance that came out just yesterday or even this morning, just around shortening up the time periods for the IBR payments. If your balance is low, then you might not really have to pay for 20 years. So lots of little things that are helping, but the core problem is that way too much money is being lent for educational expenses that are way too high, that result in incomes after education that aren't adequate to pay back the student loans. That problem is nothing so far is addressing that problem. And the cynic in me thinks it's because the wealthy people that are the beneficiaries of these very expensive educational institutions have politicians in their pocket to keep that from ever really seeing significant change in that area. But until we do, this problem isn't going anywhere. This work as a practice area will only become more viable, potentially, more demand, more profitable. So if you choose to do it, even if the guidance goes away, we were doing these cases before the guidance. For years, a year or two before the guidance, we were bringing dozens of these cases and having success. So, and inertia, the AUSAs are going to get used to using it last year and this year. And even if the guidance goes away, I still think it'll be easier to do student loan work than it ever has been, even if the guidance goes away. So, all right, questions. Let's see, other than pouring through hundreds of schedules, do you suggest how to figure out which old clients have students are way to electronic? And someone answered that there is a screening tool inside Best Case. There's also, if you use Best Case, a way to search by creditor, so you can put in the servicers that service federal student loans, Mohila, Advantage, Ed Financial, and find people with those creditors. But it is a little bit, Scott, a little bit of a manual process to kind of go through and verify those. But it's not too tedious if you leverage those tools. And I've heard the other petition prep tools have, at least some of them have similar tools to find good candidates. Tammy, I'll point out what she posted to everyone. Just if you want to try a pro bono case, for sure, there are always available pro bono cases. And again, please take advantage of reaching out to me and or Sarah. Will help you how we can, and at least get you kind of pointed in the right direction. We're learning too, right? It's new. It's pretty new as a legal practice area goes, to be ramping this up over just the course of about 2 years. We're still learning too, but we're happy to help however we can and tell you what we're seeing and what we would do under the circumstances. So, oh, that's awesome, Russ. So Trustee Brown says that he may be able to help us as well to kind of query up student loan debtors or student loan borrowers. So certainly, if you decided you wanted to take these cases, you'll be able to get work, get clients. And again, I'll even be happy to talk to you about marketing, things like that. Just feel free to reach out to me by email, and we can chat on the phone or go out to lunch or something like that and talk about this. There's plenty of this work. As I just mentioned, there could have been as many as 2,500 APs last year. I know I can't file that many, and I'd be happy to help so that we can get more of these student loan borrowers the relief that many of them are entitled to. So, A list of servicers. I'll get as comprehensive of a list as I can, Scott, and I'll post that out to ACBC. It probably won't cover everything. Oh, thank you. It probably won't cover everything, but it'll cover a lot of them. So if you don't want to do this work and you want to have send someone our way to do a free analysis, this link right here, neeleylaw.com/student loan, will take you to an intake form where either you or the client can fill it out. Either one, it doesn't matter. So you can either send the link to your client, or you can go yourself and fill it out with your client's permission. And either way, we'll get with them. We give value even if we can't help them with a student loan adversary proceeding. Okay, so we might say your best option is to get set up on the SAFE program, and here's how to do that. But we can't represent you, but here's your best option. So we'll give them value. That's why it's called a free analysis. We will give them an analysis of their best option. And it might be that the best option is to work with us. But a lot of times it isn't. A lot of times there's something else they can do that's better. So send them that way to that link, send your clients to that link, and we'll give them some good advice. All right, that's it for me. Thanks everybody. It's been awesome to be with you all today, even virtually, and I look forward to seeing more of you in person in 2024.
Well, thank you very much, Kenn. Lisa, you want to say anything?
Thank you so much. That was excellent.
Yeah. So as I mentioned earlier, well, it looks like I'm frozen.
You're not frozen.
Oh, okay. All right. As I mentioned earlier, this is being recorded, so it will be available both on the website and on ACBC's YouTube channel. We have all of our public programs, that's what this is are on both of those resources. I have sent you all a couple of times now your CLE certificate. If you didn't get them or weren't able to download it, just email admin@acbcforum.org and ask for your certificate. We'll be happy to send it out to you. So again, the materials are all at the website. I've sent you a link or instructions. It's hard for me to send you a link, but instructions how to download them off the website, or you can ask admin to send you the same. So Kenn, Sarah, this has been a fabulous program. I'm at a stage where I'm not taking on anything new, but you've now intrigued me. So
that was my goal.
Well, you know, and the practical side of it is the work's out there. And if you put together a team and you've got, you know, mentorship, et cetera, this is something that can benefit every single person that's involved in the system on all sides of it. You know, maybe not DOJ, they got to hire more people, but certainly our clients. So thank you. Any other comments, questions? All right, everybody. Well, we will see you all. Have a safe weekend and see you at our next CLE program. If you're a member, we'll see you at our happy hour. We'll see you at our Thursday think tank. Please join us. Take care. Bye.
Bye.